Okay, in this video I'm going to look at the question of how much will it cost to take the legal action. This is a question that I'm asked regularly enough, and sometimes it is impossible to say exactly. Let me explain. I'm going to look at a couple of examples of different circumstances, different situations in this video, and explain to you what's involved from a legal perspective in terms of the potential for costs and the potential legal expense that's going to arise. The first situation would be, for example, in a straightforward enough property transaction, a conveyance. In that situation, it has a very discrete, very clear beginning, middle and end, resulting in culminating in the sale or purchase of a property. I can give a conveyance fee for that with a fair degree of accuracy based on experience and so on. I can also outline what the costs and outlays and expenses are going to be. For example, stamp duty, property registration authority fees and so on. Let's take a different example, however, a more problematic example. Let's say somebody is in the employment in a job and they're having a very hard time. Perhaps they're being harassed, perhaps they're being bullied, perhaps they're being overworked, perhaps they're at risk of suffering a psychological or psychiatric injury as a consequence of the workplace, as a consequence of the conditions in which they find themselves. The first question that arises then is the employer going to be held negligent and therefore liable for any injury suffered? So an employee in that situation is going to come to me and they're going to say, how much does it cost to take legal action? And it really depends on what legal action. For example, if the employee resigned from the job by reason of the difficulty that they're facing and the experience that they're having, and in the interests of their own health and welfare, perhaps with the advice of a doctor, they've decided to resign. They may well be able to resign and bring a claim for constructive dismissal. That will be a claim to the Workplace Relations Commission, and that will involve a fairly straightforward process whereby you submit an online complaint form, you get a hearing date for the hearing at the WRC, there will be a hearing and then there will be an outcome. So that too has a beginning and a middle and an end. The problem there though from a legal perspective, just in terms of costs and so on, isn't huge as well in terms of forecasting. For example, I could tell the employee what it's going to cost for me to represent them at the WRC, prepare the submission, give them advice beforehand and so on. That's straightforward enough. Where it gets trickier, far trickier, is where the person may have a personal injury claim arising from the negligence of the employer. For example, if they have suffered a psychological or psychiatric injury, then they may be inclined to and may be advised to bring a claim to the Injuries Board, for example, for the negligently inflicted personal injury on them by the employer. In that situation, you're going to go to the Injuries Board in the first instance, and it will depend then on how the employer responds at that stage, which will be a big factor in your costs. If the employer does not agree to the assessment, and you have to, or there won't be an assessment if it's psychological anyway, so you're going to be left with, the employee is going to be left with an authorisation from the Injuries Board permitting them to bring a legal proceedings for a personal injury claim. That may be in the district court, it may be in the circuit court, it may be in the high court. Depending on how the employer deals with it, and perhaps the employer will inform or should inform the insurance company. The insurance company may take a completely different view as to how the case should be dealt with, and they may appoint their own solicitor. In that situation, you could have the insurance company or the employer looking to settle the case very early, or they could take the view that there's absolutely no way they're going to be held liable for the injury that you claim you've suffered, and therefore they're going to fight it. So they may decide to fight it. Then a case that might be resolved in 6 months could go on for years, quite frankly, because it could go to the High Court, and between the jigs and the reels, and between adjournments and notices of motion and discovery and disclosure and so on, you're going to be looking at anything up to 3 to 5 years for that case to come on perhaps for hearing. it may then settle, or it may settle in the meantime. But if you think about that case starting today, August 2021, and you don't know how the employer is going to respond, you don't know how the insurance company is going to respond, therefore you don't know how much time it's going to take, you don't know how many times you're going to have to go to court, you don't know how many times you're going to have to deal with particulars and notice of particulars, obtain medical reports and so on, then in that case you have a situation where it is practically impossible to tell you how much it's going to cost. The third scenario then would be a debt collection scenario. You might have a debt collection situation or a dispute, for example, in relation to the sale of goods and supply of services or something you've bought. You might decide to pursue somebody. You've bought a second-hand car, or you've bought some article in PC World or somewhere else, or you may have been badly treated in some hotel, or you may have a debt collection situation. You could commence legal proceedings after issuing the necessary warning letter, your solicitor issuing the necessary warning letter in the first instance. But once you do, what happens then will depend on the other party, the defendant, whether they defend the case, whether they fight it fully, or perhaps they will enter an appearance, enter a defence and then settle it. Again, what the other party does is going to determine to a great extent the cost that's going to arise, and after that then what will determine ultimately, if it's contested and if it's fought, what will determine the costs will be who wins, because the winner takes all. The loser must pay the cost for the other side. So again, when an employee comes to me with any number of scenarios, for example, they bought a dodgy car, or they got terrible service and they want to sue, or animals have broken into their property and have caused damage, then you're looking at litigation, you're looking at a contest or a legal dispute, you're looking at perhaps a settlement or perhaps a fight. That will determine to a great extent the cost that's going to be panned out eventually, and obviously who wins then will be a huge factor in who actually pays the costs. So I hope you can see from these few scenarios that I've just reeled off the top of my head that telling you exactly how much it's going to cost to bring any claim could be difficult in most circumstances. In some circumstances it's straightforward enough, but in most circumstances it's very difficult. And just to go back to the case there where a person might bring an employment claim to the WRC, I can tell them what that's going to cost, and I can tell them how much it will cost for me to represent them and so on. The difficulty then is win, lose or draw. There may well be an appeal, and if there's an appeal then it's going to go to the Labour Court. Then you're looking at more costs. And at the WRC and at the Labour Court, each party pays their own costs. So it's not a case of winner takes all. So when you go to any solicitor for advice, they'll give you advice, all right, but answering the question of how much is it going to cost to bring legal action is a difficult case or difficult question to answer, and it really will depend on the circumstances, and you do have to be aware and prepared for anything, quite frankly. And you also must remember that if you pursue somebody, if you sue somebody, if you bring legal proceedings against somebody, you must check that they're actually a mark. Because if they are a man or a woman of straw and you win your claim, you win your case, you have costs awarded in your favour against the other party, if they haven't got a bean, if they have no money, then it's no good to you. So you could have forestalled all that and avoided all that at the outset by taking some prudent review of the situation and trying to ascertain precisely if the defendant is a mark, and by a mark, do they have any money to pay you if you're successful. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.